My name is Stephanie Alexon, and I'm a lawyer here in Cold Lake with Todd and Drake, and I've been asked to come here today to talk with you guys a little bit about some of the legal consequences of unhealthy relationships, which is something I understand you have been learning about. There can be a wide array of legal consequences depending on the type of action that we're talking about, and I understand that you guys have had some questions, and those have been forwarded to me already. So there are a lot of different problems that can arise in the context of a relationship, whether that is a romantic relationship or even just amongst friends. And so some of the most common types of charges that we will see coming out of the courts relate to assaults, to sexual assaults, and to things like uttering threats and criminal harassment. So I'm just going to discuss each of those a little bit to give you kind of an idea of what you ought not to be doing if you don't want to end up in trouble with the police. So criminal harassment is something that is a relatively new section of the criminal code. Some people will talk about it in terms of stalking, but it actually is broader than just stalking. So what criminal harassment is acting in a way that causes someone else to be harassed, knowing that that's how that person feels, or being reckless as to the fact that they are harassed. And the criminal code sets out a very specific set of behaviors that make that up. So if you are to start following people from place to place, if you're repeatedly communicating with them, if you sit outside and watch either their house or their place of work, or if you engage in any sort of threatening conduct. So oftentimes, young people, when they break up, will feel compelled to try and text someone a whole bunch of times, and not even just young people, adults unfortunately do that as well, thinking that you're going to perhaps change someone's mind, or you're going to go drive and sit outside of your ex's house and see what he or she is doing. That is not advisable behavior, and depending on the circumstances, is potentially criminal behavior. So if you break up with someone and you start texting them or calling them all the time, and they say to you that they don't want you to do that they want you to stop, they don't want to talk to you anymore, that, in my opinion, from a legal perspective, is enough to know that they are harassed by it. So if you break up with your girlfriend or boyfriend, and you are texting back and forth, and they say, "Listen, I want you to stop contacting me," I would suggest that you do that, because otherwise you run the risk of being in trouble with the police. One of the other areas of potential trouble is as it relates to uttering threats. When people are fighting, when people are upset, obviously we sometimes say things that we don't necessarily mean. And so uttering threats under the criminal code is effectively when you make a threat to cause death or bodily harm, if you threaten to burn, destroy, or damage property, and also to kill, poison, injure any animal or bird that is that person's property. So whether that's in the context of a disagreement, whether that is in the context of a breakup, or whether you're just think that you're being funny, those things can, if you threaten to beat someone up, if you threaten that you're going to go and kill their dog, all of those things can constitute a criminal offense. Similarly, if you go that next step and you actually do beat someone up or have some sort of physical confrontation, assault is defined in the criminal code as the application of force without consent. So what can be an assault is a really broad range of things. And so for that reason, the type of penalty that we see associated with an assault is also very, very broad. So for example, if you are just walking down the hallway and you brush into someone by accident, and they bump into their lockers, that's not an assault because you didn't intend to do that. If you're walking down the hallway and you intentionally body slam someone into lockers, that meets the definition of assault under the criminal code because you intentionally applied force without their consent. Okay, sexual assault has effectively the same definition. It's the application of force or touching without consent that is of a sexual nature. Okay, so the interesting thing to note about sexual assault is that, unlike what you may think or that you'll sometimes see on TV, the touching does not need to necessarily be of a sexual organ. What needs to happen is that the touching has to be for a sexual purpose. The criminal code sets limits with respect to consent. So anyone who is over 16 years of age is able to consent to sexual activity. Okay. Presumptively, anyone who is under 16 cannot consent. The criminal code includes exceptions to that, however. So anyone who is between the ages of starting at 12 to under 14, so the day before the 14th birthday, can consent to activity only if the person with whom they are engaging in sexual activity with is within 2 years of their own age. Okay, so if someone is 12, they can engage in sexual activity with someone who is 14, but not 15. Even if that person willingly had sex, that is the 12-year-old, willingly had sex with someone that is 15 years old, the law says that they cannot consent. When someone is 14 years of age until they're under 16, so the day before their 16th birthday, they can consent to sex or sexual activity only if the person with whom they're engaging in that activity is within 5 years of their own age. So someone who is 15 cannot choose to engage in sexual activity with someone who is 25 years of age. The law says that they don't have the capacity to consent to that. The other thing to note is that when you're in those defined age groups, consent is not valid if the person with whom you are having sexual relations is in a position of trust or authority. So for example, someone who is your coach, your teacher, your mentor, a counselor, even if you as a 15-year-old, are engaging in activities with someone who is within that 5 years, it doesn't matter if they are it does not matter. You cannot consent if they are in a position of trust or authority. There are also some other things that are specifically set out in the criminal code that deal with consent. So in order for consent to sexual activity to happen, it has to actually be given by the person with whom the sexual activity is happening. So for example, someone else can't give consent. A friend can't say, oh, geez, my friend agrees to have sex with you. Similarly, a parent in the situation of, for example, arranged marriages can't give consent for, their child to engage in sexual activity. Consent is not valid where the complainant is incapable of giving consent. And so where that is going to be most applicable is when it comes to parties and the consumption of alcohol or drugs. So under Canadian law, intoxication vitiates consent. So it takes away consent. So even if you're out at a party and you meet someone and, you guys are maybe both drinking, and the person, male or female, says, yes, I want to have sex with you. If that person is in such a state of intoxication that they cannot, give informed consent, they cannot agree to that, then the law says that it is no consent at all, even if they seem to actively be giving consent. The opposite of that is that even if you yourself have consumed alcohol and you are the one who is either pursued or you yourself are pursuing sexual activity, alcohol does not form a defense. So if you are intoxicated and you go and you have sex with someone else against their will, the fact that you were intoxicated is not a consent, or it is not a defense, pardon me. So it seems kind of contrary that alcohol can take away your ability to consent, but it does not give you a defense if you engage in that behavior. So you just really need to be careful about what you're doing and the kind of situations you put yourself in when you've been drinking. If someone gives consent, so for example, you go to a party and you meet someone that you're interested in, you start making out on a couch, and they consent to that. That does not necessarily mean that consent carries on to all types of sexual relations. So the law in Canada says that consent has to be given for the further intimacies, okay? And that is especially true if someone changes their mind. And it's always open to someone to say, well, yes, I started consenting, but then I changed my mind, okay? So if you are engaging in some sort of sexual activity and all of a sudden your partner says, well, you know what, no, I'm not comfortable with that, we need to stop. In order to then engage in some sort of further sexual activity, there needs to be positive consent. But it talks about what is meant by consent in Canadian law. It talks about the fact that there is no such thing as implied consent. So it's not enough to just say, oh, well, she came with me into, the bedroom, or she came with me into the backseat of a car, and based on that, I assumed that she wanted to have sex with me. You have to do something to take some sort of reasonable steps to ensure that there is consent. So I know that it may seem awkward and really weird, but I would strongly encourage you all to actually have a conversation about those things. Do you want to have sex with me? Do you want to, have oral sex with me? Do you want to do all of those things? And I understand that it seems weird and it seems awkward. I will tell you that it will likely save you a whole bunch of hassle, and what you don't want to do is to have some sort of a misunderstanding and then find yourself in a situation where you are criminally charged. So SOIRA is the Sex Offender Information Registry Act, and depending on the type of sexual offense that you're convicted of, it's possible that you could be required to register as a sex offender. Now, how that looks is that there is a registry database that you have to go and provide certain information to, effectively all of your personal information about where you're living, where you can be found, date of birth, name, all those types of things. They'll also look at the actual offense and compile data with respect to if there's any sort of modus operandi, the type of offense. They'll compile all that information, and that can be used by police agencies in the future. And there's certain ways, as a general rule, the public does not have access to that, but there are certain applications that people can make to access it if, for example, it's deemed necessary. With respect to limitation periods, there are no limitation periods with respect to any of the offenses that we've talked about, and that's because they are hybrid offenses. In Canada, there are 3 types of criminal offenses. There are summary conviction offenses, and those do have a limitation period, a 6-month limitation period. A hybrid offense is one where the Crown prosecutor gets to choose how to proceed, whether that's by summary conviction or by indictment. An indictment is the most serious way to proceed under Canadian law, and that usually carries with it the strongest penalties that we have. So where the Crown has an election on a hybrid offense, they can just choose to proceed indictably, and in Canada there is no time limitation to lay an indictable charge. It could be within 6 months, it could be 10 years down the road, it could be 20, 30 years down the road. And so with the movement with respect to sexual assault survivors coming forward, we're seeing that there is some people who are coming forward for historical sexual assaults that happened 40 years ago. So there is no limitation with respect to any of those types of offenses.